Go ahead. Good afternoon, and welcome to our partner webinar series, Planning Mistakes and How to Avoid Them. And special thanks to the LRM Group. We appreciate their partnership in presenting today's session. I want to mention a couple of upcoming chapter events. We've got the Future of Talent and Financial Planning, Strategies for Attracting, Developing, and Retaining the Next Generation of Advisors on August 14th from 8 to 10 a.m. at the Buckhead Club. Webinar series Rethinking Loan Qualification, the Power of Non-Agency Lending Solutions on August 19th from 12 to 1. And our next quarterly meeting, Empowering Better Futures for Aging and Special Needs Communities on October 16th from 8 to 10 a.m. at the Buckhead Club. Check our website for details, regular updates, and register now. We are thrilled to be joined today by Bradley Ewell, an independent insurance advisor and advanced insurance planning consultant with the LRM Group, and Sean Link, estate planning specialist with the LRM Group. Before we dive in, please use the Q&A feature at the bottom of your Zoom screen to share questions or comments throughout the session. We want this to be interactive and valuable for you, and they'll address those at the end of the presentation. And with that, I'll turn it over to Brad to begin.
All right, perfect. Thanks so much, Kathy, and good afternoon, everybody. Hope you guys are all doing well today. Really excited to be here with you guys. As mentioned, my name's Brad Ewell. I'm an insurance consultant with the LRM Group, and I've been a part of the FPA for the last 2 years now, and this is the first year that our firm has sponsored the FPA. So I'm actually based out of Woodstock, Georgia. Born and raised in Georgia a lot of my life, but recently moved back to Georgia 2 years ago when I joined the FPA. So I'm also joined by Sean Link. He is our estate planning specialist with LRM Group as well. If you guys were at the annual meeting this year, both Sean and I were there. And we did a presentation very similar to what we're going to go through today. If you remember, or for those that attended, what we did was a Jeopardy style multiple choice question and answer. So it should be a fun way to go through this topic. And what we focused on previously were life insurance mistakes to avoid. Kind of on multiple different levels, but a lot of it really kind of from the personal life insurance planning. So today, the format that we're going to be focusing on, a lot of which is going to be around business planning. So life insurance mistakes to avoid when you're looking at business planning, as well as estate planning and some personal just life insurance planning situations as well. So hope you guys enjoy the topic that we go through. Again, yes, please use the question Q&A feature. We should have some time at the end of the presentation to address those. But before we get into the main meat of the conversation today, first, just want to give you guys all a little introduction as far as who we are as a firm and how we can be here to support you guys. So LRM, it stands for Legacy and Risk Management. So as Kathy mentioned, we are an independent insurance consulting firm, and we work all across the United States. So we work with RIAs, both fee only as well as fee based, in pretty much all 50 states. And one of our main goals is to help you guys to enhance and protect the relationships that you guys have with your clients. And we do that through helping you guys complete the planning that you guys are doing with your clients every day when it comes to life insurance, long-term care, disability, and annuities. So really any situation from somebody that might need an introduction to one of these type of conversations and do some of the this basic planning, all the way to individuals that have a whole host of these type of insurances already in their portfolio that might need to be reviewed and evaluated to see, do they keep doing what they're doing, or should they make some tweaks to the policies as they exist today, or would something new be better altogether? So we can help with all those levels of analysis. And like many of the independent advisors that we work with, they affiliate with some type of network or an association, like XYPN or NAPFA, or we also work with Garrett Planning Network, if that's something you guys are familiar with. But our firm, being that we're independent, we have a network that we affiliate with very similarly, which what that does, it gives us access to really all the carriers, all the top carriers in the industry when it comes to these product lines. Um, and so we have access to really all the top products and a really a vast array of a network system and support directly from these carriers. So I bring that up because, really behind us, we have a lot of firepower that we can bring to you, to your clients, to really make sure that we're getting your clients in the best product for their situation. So the next bullet point that you guys see up there, advisors are our clients. We like to say we take a little bit of a different approach than many insurance groups, where we don't go out and solicit our own direct client business. All the clients that we get come directly from the advisors that we work with. So given that, in a lot of different ways, we invest into our company to provide different services to you guys that you can tap into because again, you guys are our clients, and I'll get into that here in a second. Um, but that next bullet you see there is we act on your behalf. We don't solicit your clients. Most all situations that we're dealing with, if there's a certain recommendation that you're wanting the client to get, oh, they need $1 million of term insurance or need 5,000 a month of disability or whatever it might be. We're here to honor those recommendations. We can also take clients through needs analysis processes as well. So really, depending on the level of engagement you want us to have with your client, we're open to that. And and again, you guys can kind of dictate, where we're going to step in. But in no means do we ever reach out to your clients without, consent from you first. Then that last bullet point, we really pride ourselves on taking a very educational and consultative approach when it comes to analyzing insurance for your clients. Um, Ultimately, there's no type of fee or anything like that we charge advisors to work with us. Really, the only way that we're ever compensated is if it makes sense to put a new solution in place for your client. But by no means, no relationship with our advisor is ever more important than any single sale. So, really just like you guys go out and build the trust and confidence with your clients so that they, continue to work with you. We want to do the same thing. We want you to have that same trust and confidence at us that when you bring a client our way, that we're going to take care of them with the respect that you take care of your clients with. And if we do this the right way, then it's just you'll continue bringing clients after clients to us, and we'll find the right opportunity to put a new solution in place. So that last piece, if it's important to you, it's important to us. I like to say from your smallest term case to your largest business planning or estate planning situation, we're here to consult with you and consult with your clients to again make sure we put the right solution in place. Then, as I mentioned, with advisors being our clients, these are some of the types of services that we reinvest into our business to support you guys' practices. So these are really kind of in addition to the typical situations that might come your way of Bob and Sue need some term insurance or look into disability or long-term care. So these are well-defined processes that really you guys can tap into to enhance your practice. So you see we've got policy review, estate review, and business review. So just like policy review stands, we have a process, especially when it comes to life insurance. I think a lot of us know that anytime you're evaluating a person's existing policy, there's a lot of information that you typically need to reach out and get in with in-force illustrations and policy values and cost basis. So we can take a lot of that work off of you and your clients, where we can get the client to sign a third-party authorization that basically gives us the authority to request all the information, to do a thorough review and evaluate. Again, should they keep doing what they're doing, or should some changes be made? Then our estate review, this is actually headed up by Sean Link, who he's going to be along with me taking us through a lot of this presentation today. But basically, any situation where a client needs to approach estate planning that might not have anything in place, all the way to somebody that has a full estate plan set up that needs to be reviewed. So Sean, he can't act on behalf of anybody as their attorney, but he can be there to speak in their situation, provide a formal review if they have things like what's listed above, existing trusts, wills, powers of attorney, other estate planning documents, can review those and kind of do a SWOT type of analysis to see if it makes sense to make any changes. And then similarly with our business review, we do a lot of work with business owners. So in those functions that you see that need to do some buy sell planning, maybe executive benefits, we have a way of getting formal or kind of informal valuations done on businesses that go a long way to help supporting the types of coverages that we're looking to put in place. But anything from somebody that needs to approach business planning all the way to reviewing an existing plan that they might have in place, which is something we'll talk about today. So, but all these, no cost to utilize any one of these services. Again, they're just really designed to be here to help make you guys look good in front of your clients, where you can come back to them with a lot of great information on their personal situation or business or estate planning. All right, so last piece. So this is the team that's supporting all of you guys at the FPA. You see myself and Sean up here. Al Lorenzi is one of our principals and co-founders of the firm, and Chase Crawford is our case design specialist. So he's here to he works in a lot of these various review programs that we have. So I'm the lead contact for most interactions with advisors and clients. But you guys, we'll put up a slide with our contact information. You guys can reach out to any one of us at any point in time. And we're all here working and kind of rowing in the same direction, collaborating on any situations that you may bring to us. So, all right. So with that, I'm going to pass it over to Sean. He'll give a just brief introduction as far as what to expect for the rest of the presentation.
Thank you, Brad. Thanks to all of you for joining us today. We very much appreciate it. So as Brad kind of mentioned earlier, we're kind of going to make this a little interactive, a little fun. So we're going to be putting up some multiple choice questions on screen. And once Brad or I finish taking you through the question and the multiple choices, you'll see a little poll dialog box pop up on your screen where you'll be able to vote for what you think is the correct answer. And then once we collect the votes, Brad or I will take you through what the correct answer is and why, and also how we can potentially help when you have clients in these situations. So to kind of dive right in, see how this works, we'll start with our first question. So a successful business owner creates a revocable living trust and transfers her closely held business interest into the trust to mitigate estate taxes upon her death. She also names the trust as beneficiary of a life insurance policy intended to fund estate taxes and provide liquidity at death. Which of the following statements best describes the planning mistake in this scenario? A, naming a revocable trust as beneficiary of a life insurance policy has the same effect as naming the estate as beneficiary. B, assets, including life insurance proceeds in a revocable trust, cannot be used to pay estate taxes. C, a revocable trust does not remove ownership or control for estate tax purposes. Or D, business interest should never be titled in the name of a revocable trust. So if I'm doing this correctly, you all should now see a poll question pop up on your screens. Feel free to vote for what you think the correct answer is. Okay, we got some votes coming in now. Not as many as folks we have in attendance, so make sure you get your votes in. Okay, now they're streaming in. Okay. All right, decent mix amongst the options here. All right, we'll go ahead and call it there, and we can show the results. That again, decent mix of results, but vast majority of you, good work, did land on the correct answer, which is C, a revocable trust does not remove ownership or control for estate tax purposes. And I think this is unfortunately a pretty common misconception, especially among clients. They not knowing the depth of the various intricacies of trusts, think that The revocable trust they have confers the same kind of benefits from an estate and tax perspective as an irrevocable trust may. So that is the mistake that our business owner made in this case. A is simply not true. If a revocable trust owns a life insurance policy, it won't have the same effect as naming the estate as beneficiary. The death benefit will still be distributed to the revocable trust and bypass probate. But as we saw in answer C, it doesn't get those estate tax benefits because it is a revocable trust and not an irrevocable trust. For option B, just simply not true. Oftentimes, revocable trusts are in fact written with provisions that allow the assets therein to be used to pay estate taxes and fees. And D is also just simply not the case. Very well can put business interest into the name of a revocable trust. So good first outing on our first question, Brad. And I will pass it over to you for question number 2.
All right, perfect. Good work on question 1. So question number 2. Which insurance planning mistake most commonly results in unexpected or unintended income or estate tax consequences? A, utilizing permanent insurance when term would suffice. B, overinsuring the client. C, holding insurance in a revocable trust. Or D, improper policy ownership structures.
Okay, and here comes the poll. A couple of you real quick on the buzzer. I like it. All right, give you a few more seconds to get your votes in. All right, we'll call it there. Not as much variance here, but again, the vast majority of you managed to find the right answer here, which was D, and Brad's going to tell you why.
All right. So I think this is a very important point to bring up because I find a lot of advisors are under a misconception of how policy ownership works with policies or with life insurance contracts. So unlike option A states, it's not the type of policy, but it's really who owns it that ultimately drives the taxation of the contract. So incorrect ownership can result in many different tax issues, but number one is estate tax or estate inclusion. So the issue that I see a lot of times is people are unaware that if any policy that you personally own, it counts towards your estate value. So, for the example of if you've got a client that's worth $10 million, but they also have $5 million worth of life insurance that they personally own, even though that policy might have the beneficiary as their kids, whenever they pass, whatever life insurance is in their name counts towards their estate value. So at their death, if they have a $10 million net worth, that $5 million life insurance counts towards it. I know estate tax exemptions are high now, where it's $15 million per person, but as we know, that is subject to change. So ultimately, any of your higher net worth individuals that have life insurance, a lot of times it makes a lot of sense to have those type of policies put inside of irrevocable trusts to, again, keep that value out of their estate. Where life insurance, it's a somewhat of a unique type of contract where there's three distinct parties for the most part of any contract. You've got the owner, you've got the insured, and you've got the beneficiary. So another issue that we run into a lot of times is if you ever have all three of those individuals as different entities, then that can actually make the death benefit taxable. And I'll tell you a situation I ran into recently. We had a 92-year-old woman that she was the owner, she was the insured, and her three kids were the beneficiaries. But one of her sons was the primary person that was taking over all of her finances. So she transferred the ownership of her policy to that one son. So now we were in an issue where son is the owner, she's the insured, and her three kids are the beneficiaries. So ultimately, if she were to pass, that death benefit would be looked at as a gift from the one son to the other kids. He would get his portion of the death benefit tax free, but those other kids, there would be gift tax associated with it because of the three party to the contract. So it's so important to, just like any other financial product that your clients might own, it's so important to check the beneficiary structure and make sure that they stay in line. So this situation, can happen on a personal situation as well as business. Where we see this in business owned policies. If you have a corporation or a company that owns a contract where they've got an owner or a key employee as the insured, and if they name their spouse as the beneficiary, well, now we have three parties to the contract, where that death benefit in that situation would actually be you'd have to pay ordinary income tax on that death benefit in passing to the ultimate beneficiary. So ownership structure is very important to look at.
All right, moving on to question number 3. Which estate planning decision most commonly results in unintended estate tax inclusion despite the use of an irrevocable trust? A, naming a spouse as trustee. B, retaining indirect control over the assets. C, funding the trust with life insurance. Or D, using a crummy withdrawal provision. Go ahead and get your votes in. Oh, Brad, we might have made this one a little too easy. All right, everyone I think has their votes in and just absolutely knocked it out of the park. Almost everyone getting the correct answer, which is B, retaining indirect control over the assets. It's a classic hallmark of what results in basically the IRS stepping in and say, hey, you created this irrevocable trust and wanted us to kind of discount the assets therein from being a part of your taxable estate. But part of that is that you're supposed to give up control and access to the assets. And I see it, unfortunately, far too often where folks forget that or try to play a little fast and loose with that. And it's just a fast track way for the IRS to absolutely discount the irrevocable trust and the benefits it confers. None of the other options here are going to have that unintended estate tax inclusion. I will say A is a bit of a red herring because there are some times where naming a spouse as trustee would result in some unintended estate tax consequences. But with proper planning, that's incredibly rare and can certainly be planned around. Absolutely B, if a client retains any kind of indirect control or access or benefit from the assets in their irrevocable trust, that is going to be the nail in the coffin for that trust being treated as outside of their estate and therefore outside of the taxable estate. All right, moving on to question 4. Brad, take it away.
All right. Question 4. A financial professional recommends and places life insurance for estate liquidity, but does not review the policy for 10 years. What is the most significant risk by the failure to review? Is it A, declining carrier ratings, B, policy underperformance relative to assumptions, C, beneficiary dissatisfaction, or D, increased underwriting costs?
All right, votes are streaming in. Brad, I think we're going to have to make some of these questions harder.
Yeah,
We got a good group today.
Yeah, this one might be a little easier, but I promise there's some hard questions coming up.
All right, we'll go ahead and call it there again. Vast majority of you right on the money with the correct answer of B. And Brad, take it away.
I see there was one answer for A, which I'll hit on that, where that can potentially be an issue, but it's by far not the most or the biggest reason it's so important to review policies. So I think many of us know whenever we run into a client that has an existing life insurance policy, that most people, when they buy it, they really don't ever review it. The vast majority of people that I work with that have had a policy for 20 or 30 years, they've never gone back and had a formal review of that contract because people buy it. They think, oh, I'm paying my premiums every year. They get their annual statement. They might look at it, but then they just file it away and think, hey, I'm paying my premium. This policy is going to continue performing. But as we all know, and one of the phrases that I like to use the most is you want to think of your insurance like any other asset that you have, just like your IRA or 401k or a brokerage account. You don't just aimlessly put money into it and never review the performance with it. So, especially with permanent life insurance, every permanent life insurance policy, for the most part, is building some type of cash value. And that growth inside the policy, it's either based on some underlying fixed account, it might be an index-based product based on, some S&P 500 or other type of index, or variable policy that has underlying mutual funds. And when you initially take a policy out, its performance is predicated on getting a certain level of return, which may or may not happen. So, and as we all know, people don't always fund their policies on time, or they might take loans or withdrawals, or they just might not get the proper performance inside the policy. So it's so important, at a minimum, to review contracts at least every 3 to 5 years. I would say that at least half of the policies that I look at, there's some type of internal change that needs to be made so that the policy is going to last long term and, last as long as the client is typically the goal with a permanent life insurance policy. But besides that, life insurance, it's unique where when you buy life insurance, typically the only time that policy typically or meets your needs is when you initially buy it. Then things change where you have kids, you start building a nest egg, so you might not need as much insurance down the road, or, kids grow up and leave the house. Beneficiaries that were originally getting the policy pass away. So a lot of things change. So it's important to kind of reevaluate and reassess needs as they move along the lines and as people age. But one situation that always comes to my mind with policy underperformance is we had a situation brought to us where somebody in their early 80s had a whole life policy that lapsed on them. And if you guys know, if a policy ever lapses, whatever gain is in the policy, if there's a taxable gain, it's due at the time of death. And in this situation, so this person was in their lower 80s, and they got a $900,000 taxable gain from their life insurance policy that had lapsed. They had taken it out basically in the mid 80s, where interest rates were really high. And what they were told is they could pay 5 premiums, and then the policy was going to be able to sustain itself for the rest of the life of the contract. They never reviewed it, and what happened was, as we know, interest rates just continued to decline. Also, the dividend rates declined. So ultimately, what happened, that policy was taking loans to keep it in force, and ultimately it was no longer able to do it, so the policy lapsed. So that would have been a prime situation where if they had been reviewing it and come to us, even 5 years before that policy got to the point that it was lapsing, we could have made, work to make some changes to keep them from facing a $900,000 1099, which with life insurance, any 1099, it's ordinary income tax that's due, not capital gains tax for any existing policy. So again, so important. Review policies regularly, and that's probably one of the areas that we assist most with advisors. So, Sean?
Yeah. Moving on, we're getting to halfway through already. So question number 5, client owns a closely held business valued at $8 million and has 2 children. One child is active in the business and is expected to inherit it. The other child has no involvement in the business. Client's remaining estate consists of $2 million in liquid assets. Client wants to treat both children fairly. Which of the following strategies might be most appropriate to accomplish the client's objectives? A, divide ownership of the business equally between both children. B, leave the business to the active child and use life insurance to equalize the inheritance. C, sell the business at death and divide the proceeds equally. D, place the business into a revocable trust with the children as equal beneficiaries and name the active child as trustee. Go ahead and launch the poll here for you. Okay, again, we got a great crowd today. You're all right on your A game, and again, overwhelming majority of the votes coming in are for the correct answer, which is B. With this one, this is something that we see a lot, conversation that we have a lot with when we do business reviews and business consulting. It's I think more common than people realize when you have a family business, and oftentimes you have one out of two or two out of three or one out of three children that are really involved in the business. They've worked in it their whole life, and the other children just, for whatever reason, were never really a part of it, never really that important to them. But when it comes time for succession, in terms of both, the business succession and how that kind of pairs and meshes with estate planning, the question is, well, how do you do that equally and fairly? And there's kind of an old saying in estate planning when with clients that fair doesn't necessarily mean equal, and equal doesn't necessarily mean fair. Every client, depending on their situation and their family dynamics, is going to have a different idea of what is fair and what is equal. So in a situation like this, it may be equal to just divide the estate right down the middle between the two children. But is that really fair that one child who has worked their whole life in the business and has put their blood, sweat, and tears into it, and is going to continue working it and potentially take over in terms of leading the business, is going to own 50%, while the other child who has never really been involved whatsoever and doesn't really know the business is also going to have a 50% ownership stake. So again, it's getting at the heart of, well, how do we do things equally yet fairly? Answer A is something, like I said, that often leads to just way too much strife and conflict for the reasons that I mentioned. Same thing with C, kind of just from the other side of things, is that it may divide the proceeds equally, but you have to sell the business in order to do that. And that's one of the things that we highlight in the fact pattern, is that, look, this business is a significant portion of the estate. There's not a lot of liquidity to just do 50% each without either again, dividing the ownership of the business or selling the business to meet those liquidity needs. And D, I suppose that there could be some folks out there that might try this, but it's, again, really not going to accomplish much from the standpoint of trying to be equal and fair. So B is something that we talk about often, where, in this scenario, you could have the child that's been involved in the business inherit the business entirely, and then utilize some of those liquid assets to fund a life insurance policy for, in this case, $4 million, so that you can give the non-active child an equal share of the estate without having to cause that strife or liquidate any portion of the business. So estate equalization is a big topic that we often talk with advisors and their clients about, and it's only all the more important when it comes to family-owned businesses. All right, Brad?
All right. Question 6. Two equal business partners enter into a cross-purchase buy-sell agreement. Which course of action most often causes the plan to fail at the time of death? Using term insurance instead of permanent insurance. B, not adjusting the death benefit amount as business value increases. C, failing to coordinate ownership of policies with the buy-sell agreement. Or D, valuing the policy annually.
Go ahead and get your votes in, everyone. Okay, getting back to a little more variation, a little more of a split between the options. All right. But again, the majority of you are right on point, in the correct answer being C. Brad?
All right. So this is an important point to bring up because anytime you're working with a business owner and doing some level of buy sell type planning, there's really two parts of any type of buy sell planning. And number one is the agreement. So where you're putting the agreement in place, a lot of people you're probably familiar with cross purchase buy sell or entity purchase buy sell. So depending on the plan that you're doing, the actual function of the funding of that agreement needs to be set up properly. So in this situation, so cross purchase, we've got two owners. They're each buying life insurance on each other. So if me and Sean are in a business together, I own the policy on him, where I'm the beneficiary, and he owns a policy on me as the insured, where he's the beneficiary. So it's so important that if you have the life insurance policy set up in that cross purchase function, that you also have an executed agreement, buy sell agreement that supports that. Hey, in the event that I pass away, Sean is required to use those life insurance proceeds to purchase my portion of the business. And this was a situation that Sean ran into somewhat recently, where he was reviewing the buy sell agreement that a business had put in place, where they had it structured originally as an entity purchase type plan. So both, instead of buying policies on each other, the business owned a policy on each one of the owners, where the business was also the beneficiary. But ultimately, down the line, one of their CPAs looked at it and said, "Hey, there's you guys really should structure this as a cross purchase plan. There's a benefit with doing cross purchase that ultimately, in the event of passing, the other business owner gets a step up in basis in their value of the business when using a cross purchase plan." So, yes, while it did make a lot of sense for them to go ahead and update their plan to cross purchase, they failed to update the buy sell agreement, which basically was set up for entity purchase. That in the event of one of them were to pass away, that the business would purchase the value of that of their share of the business from their family. So because they didn't update the buy sell agreement, it now was no longer enforceable because they had switched the life insurance funding to cross purchase style. So again, I think this really highlights the importance of making sure your agreement matches the funding. When you look at the other answers, A, using term insurance instead of permanent, both can be a valuable way to do this, depending on really just the goals of the business. Sometimes we use term insurance and sometimes we would use permanent. So both can work. B, not adjusting the death benefit as the business value increases. Again, that's another important thing to think about. And I will say, if you guys aren't familiar, there are certain life insurance carriers, Principal being one of them, where you actually have the ability to put a amount of coverage in place where you reserve the ability to increase that coverage as the business value increases. So there's some unique ways of getting some buy sell funding that um, you know, doesn't require you to go out and buy additional policies as the business value increases. And then that last one, valuing the business annually, might be a little overkill, but I mean, it is very important to review the business on a regular, kind of a regular cadence every 2-3 years to make sure that the insurance is still meeting the obligation.
Yeah, so the case that Brad mentioned that I was involved in, it was one of those scenarios where you had, a financial professional, I think it might be a CPA or something, that knew their stuff, but they didn't necessarily understand the intricacies of insurance and things of that nature. And unfortunately, we get that sometimes where, a client's going to have a team of professionals, and one may recommend some kind of strategy or change to try to improve one aspect of the client's situation, but not fully appreciating what ripple effect that might have on the bigger picture. And luckily, that advisor brought their client situation to us, to do a business review. And during the business review, we obviously caught that said, hey, you've changed the ownership arrangement of these policies to be contrary to what your agreement says, which is a bit of a problem. All right, moving on to question number 7. So, which action is most likely to create a transfer for value problem in life insurance plan? A, changing ownership of a policy from an LLC to an individual member. B, naming an irrevocable trust as beneficiary. C, funding a policy with annual exclusion gifts. Or D, converting a term policy to permanent insurance. Go ahead and get your votes in. Okay, again, a little more variance on this one. Okay, I'll go ahead and call it there. And just by a hair, it was I thought we weren't going to have a majority for the first time, but just at the very end there, somebody got their last vote in for the correct answer, which is A, changing ownership of a policy from an LLC to an individual member. But some other options were selected as well, and I think that that's understandable because transfer for value is, I think, an area that a lot of people really don't think about. They don't consider it enough when they're talking about life insurance planning and specifically ownership of policies. So just to give you a little bit of a history lesson, I always think it's somewhat helpful to understand transfer for value or anything really by understanding why it exists in the first place. Decades and decades ago, they created the transfer for value rule basically to dissuade and prevent people from, for lack of a better term, buying and trading in life and death. They didn't want life insurance to be able to be swapped around and sold almost like a commodity, or like a stock trade where the stock is somebody's life. So that's why the transfer for value rule exists. They basically said, hey, if you're going to transfer ownership of a life insurance policy for valuable consideration, then we're going to hold that life insurance will no longer receive the kind of hallmark benefits of life insurance, such as being the death benefit paying out income tax free. And one thing that I always like to educate people on is that value has a much broader definition legally than it does just kind of in our everyday parlance. It's not just money. Transfer for value can be the value of labor. So the transfer of value problem can come up in when you're talking about policies that businesses own on employees or things of that nature. That value can be labor or the agreement to a contract, things of that nature. So that is why A is the wrong answer or excuse me, A is the correct answer. The thing that is wrong to do because it's not one of the several exceptions to the transfer for value rule. There are exceptions like if you're transferring the policy to the insured or the partnership of which the insured is a member. Things like that are exceptions to the rule where they've carved out, as things are often the case, they come up with a new rule to fix a problem, and then people say, "Hey, wait a second, there are some legitimate reasons why we might need to transfer a life insurance policy here." So they carve out exceptions, and as I said, they carved out about 6 exceptions to the transfer of value rule. But one of them is not uh, transferring ownership of a policy from an LLC to an individual member. Again, transferring the policy directly to the insured or a partnership of which the insured is a member can get you around the transfer for value rule, but LLCs are not the case. And one of the issues, going back to the last question, that example we used, that case that I worked on, it only kind of compounded the issues because when they were doing the ownership transfers, they were, again, not respecting the transfer for value rule, and they just really made a bit of a mess for themselves by not calling in insurance experts to say, hey, this is what we want to do. Can we do this? If so, how can we do this without jeopardizing our situation, running afoul transfer for value, making sure that it jives with our with our buy-sell agreement, all of that. So transfer value is something to always keep in the back of the mind. And as always, we're available to help assess and consult in situations where that might be an issue. Throw it back over to Brad for question number 8.
All right. A business has a cross-purchase buy-sell agreement funded by life insurance. What planning issue may commonly arise as the number of owners grows? The death benefit becomes taxable to the surviving owners. B, cross-purchase agreements cannot be funded with life insurance. C, the agreement terminates automatically if a shareholder is added or dies. Or D, the number of required policies increases as the number of owners increases.
Poll is live. Go ahead and get your votes in. We got a good number of votes in already. Little less variance in this one. Admittedly, a bit of a softball question, but it's important that we discuss it because it's something that is really paramount to the analysis of putting buy sell structures in place. So go ahead and show you the results there. Most of you got the correct answer D. I'll let Brad go ahead and tell you why.
So exactly right. So yeah, this one probably was a little bit easier of a question, but kind of like we talked about before, when it comes to deciding, do we do an entity purchase? Do we do a cross purchase plan? There are some significant tax benefits of doing a cross purchase arrangement. Number one reason, again, from the standpoint that the individual owners get a step up in their cost basis and the value of the business when doing cross purchase over entity. So a lot of times individuals really, the goal is to do cross purchase if possible. But the downside is as you start getting more and more owners, the number of policies needed grows very rapidly. So, in a case where you have 4 owners in the business, every owner needs to own a policy on the other 3. So if you've got 4 different owners, now we're in a situation where we're potentially buying 12 different life insurance policies to do a cross purchase plan, which can be a little cumbersome to keep track of long term, especially if you get in a situation where we start adding additional policies down the road. The number just starts increasing exponentially if we need to now everybody else buy another policy because the value of the business has grown. So there are some unique ways of setting up cross purchase plans over the traditional just everybody buy a policy on each other. There's what's called an insurance LLC or buy sell LLC, where you can in essence have the benefits of a cross purchase type structure without the need for everybody buying individual policies on each other. So you kind of get back to the every owner in essence, one policy for every owner when it's housed inside of an LLC versus all being individually owned. So there's some unique ways of approaching this, and depending on the individual business, there's considerations we can look at. Does that make sense, or should we just keep it more standard? And we've got a lot of owners. Let's just set it up as an entity purchase, a traditional entity purchase plan for simplicity purposes of managing. So.
And just a final note for any math nerds out there, if you're ever wondering how many policies would be required to do a cross purchase agreement based on the number of owners, write the little equation here. I remember that I have a touch screen this time. I'm not trying to do this with the touchpad. So n times n minus 1. If you're ever wondering, that's the equation that'll help you figure out how many policies you're going to need, and therefore might dissuade a client from going that route. Because say if you have 6 owners, n is 6, so 6 times 6, 6 minus 1, 6 times 5, you're going to need 30 policies to effectuate a cross purchase agreement for a business with 6 owners. All right, moving on to question number 9. A business has a buy-sell agreement requiring the purchase of a deceased owner's interest at a fair market appraisal value, which is currently $5 million. But the insurance policy funding the agreement provides only $2 million of death benefit. Which is the most likely consequence? A, the surviving owners must fund the remaining purchase price from other sources. B, the agreement becomes unenforceable. C, the IRS will adjust the purchase price to match the insurance proceeds. D, the deceased owner's estate must accept the insurance as the full payment amount. Launching the poll now. Go ahead and get your votes in. Okay. But a bit of a split here, about two thirds of you for A, one third of you for D. The correct answer, the majority of you did get it right. That is A. The surviving owners must fund the remaining purchase price from other sources. This question has a few different layers that we like to highlight. The main one just being that this is a reason that buy-sell agreements and the underlying funding of them need to be reviewed because when the value of the business begins to outpace the funding for the agreement, then you can be in a situation where something unfortunate happens to one of the owners. There's a mandatory buyout because of the buy-sell agreement, but the funding is just not there. How do we make up that additional cost? Do they have to, take out a loan? Do they have to liquidate assets of the business in order to fund it, depending on the structure of the agreement? So it's very, very important to review not only the buy-sell agreements, but the funding for the buy-sell agreements. Um, Answer B, unfortunately, the agreement doesn't just become unenforceable because the funding's not there. The agreement is still very much enforceable, that whether it's entity purchase or cross purchase, that either the business or the surviving owners are required to purchase the shares. C, the IRS will adjust the purchase price to match the insurance proceeds. Not the case, but this is another layer to this question. The IRS adjusting the purchase price was essentially what the folks in the Connolly decision. I don't know if you hopefully heard about the Connolly decision. It was a Supreme Court case from just about a year and a half, couple of years ago now, where it kind of changed the landscape for buy-sell agreements because you had a couple brothers, the Connolly brothers, who were running their family business, and when one of them passed away, they kind of played fast and loose with their agreement. They didn't do what was required of their agreement. They didn't get their valuations. The business was valued at, I think, you know, uh, say $10 million or $8 million, whatever it may have been. They had a 50, if they had a 50% ownership share, but they only had, I think, $3 million of insurance for each brother. And they basically they tried to do that and say, we have $3 million of insurance, so we'll just call the value of the deceased brother's share of the business that amount and try to get away with that. But the IRS came in and said, "Oh, no, 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 no! You don't get to just make the value of your business whatever funding you may have to effectuate the buy sell." So the Connolly decision was a big impact in the business succession buy sell world, and there's a lot of nuance to it. It can have very profound effects for business owners that have an entity purchase agreement. If you have business owners that have entity purchase agreements, or you don't know what kind of purchase agreement they have, please, by all means, reach out to us because we'd love to review and consult in those situations. Because again, it can have big consequences for those entity purchase agreements, but moreover, it's really what the Connolly decision was kind of a wake up call that folks need to be aware what their agreements say. They need to follow what their agreements say, and I'll stop saying it when it stops being true. But I don't think there's ever been a time where we've been involved in a review of a buy sell funding business succession situation where we haven't found something that was amiss, whether it was underfunded, whether they weren't following their agreement as they were supposed to, whether there were things in their agreement that they didn't know or forgot were in there. It is very imperative that if you have business owner clients, that they are reviewing their documents, reviewing their funding, and we get it. they're busy. They're spending the day to day keeping their business running. That's why it's incumbent upon us as their advisors and insurance professionals to take that burden off and say, hey, we have folks that can look at this for you and assess the situation and see if there's anything that might be wrong. All right. So for our last question, Brad, take it away.
All right, rounding it out. This might be a little bit of a tougher one to end on, so we'll see how it plays out. But number 10, two equal business partners have a buy-sell agreement requiring the surviving partner to purchase the deceased partner's interest. To fund the agreement, each partner owns a life insurance policy on the other, so cross purchase. One partner later transfers the policy into an ILET as part of their estate plan. What potential issue is most likely to arise? A, the life insurance death benefit may be subject to income tax. B, the ILET may not be obligated to use the death proceeds to fund the buy-sell. C, the policy will automatically be included in the insured's taxable estate. Or D, the cross-purchase buy-sell agreement has become an entity purchase agreement.
All right, go ahead, get your votes in. A few more votes coming in. Thought we were going to stump them, Brad, but I don't think that much. I don't think that's the case. We got a sharp group with us today. All right, I'll go ahead and call it there. Again, the overwhelming majority of you hit it right on the head. The correct answer is B.
All right, perfect. Well, I was thinking D was going to pull more people in, but yes, B is correct. This is really another situation that we've run into, and it's a similar story, like I mentioned before, where that financial advisor firm, changed their cross purchase plan into an entity purchase, but did not update the agreement. So another situation where it's you can do something that seems smart on that individual basis, but the ripple effect, it ends up hurting the entire plan. So, um, the whole idea behind moving a life insurance policy into an ILET is good in itself from the standpoint now that policy is, for a higher net worth individual, it keeps the death benefit out of their estate. So that's good. But again, now it's violating, in this case, the buy sell agreement. And if your agreement is set up as a cross purchase structure, moving that life insurance policy into the ILET, it now is no longer in that cross purchase setup. So that's where D kind of comes into play. The cross purchase buy sell has become an entity purchase agreement where it hasn't really become it. But yeah, that's the ultimate issue where now that money's in the trust is may not be obligated to use those proceeds to buy the business. So now puts them that business owner in a bad situation. So
Yeah, and this was based on a case. This is a real case out of California, where essentially this is what happened. Where you had I think in the actual case, there were more than two partners. There were, I think, three or four partners. But one of them, they had their agreement in place, they had all their policies, everything was good. But essentially, one of the owners came to the others and said, "Hey, I was talking to my CPA or my advisor or whoever it may have been, and they said I might have some estate tax issues, and this policy I have for our business would be better suited if we put it in my irrevocable trust. Is everyone okay with that?" And all the other owners, again, not really knowing the implications, said, "Yeah, sure, that makes sense. We hate estate taxes too. We wouldn't want to pay them either." But the problem is what the court held in that case is that the policy is now owned by an entity in the irrevocable trust that isn't party to the agreement. It would just be like if Brad and I had some kind of contract together to sell something or loan something, and I went and sold it to somebody else or loaned it to somebody else. It's now, Brad can't go to that person and say, "Hey, sell me this thing," because they weren't party to our original agreement. And that's what the court held in this scenario. So again, Unfortunately, we see it far more often than we should, where situations are the fact that a client hears some advice or a friend tells them that they should do this or do that, or they go on and get something from Chat GPT or whatever it may be these days, where they think that they're improving their situation, they think they're making the right moves, but really they're doing something that's going to cause massive headaches down the road. So that's really the takeaway from this one, and really glad to see you all. We're again right on the money with that.
All right. Well, I don't see any questions in the chat. We're right up on time. So just again, want to thank you guys so much for joining the presentation today. I put up the contact information for both Sean and myself. So, if this has got you guys thinking about any individual situations that you would want to run past us, again, feel free, reach out anytime. I've really enjoyed getting to know a lot of you guys over the last couple of years, and look forward to to working with you guys if there's any situations that we could help with. But again, take advantage of the various review services I mentioned, everything from policy review, estate review, business review. I'm sure what we went through today probably sparked some thoughts in you guys' mind. So if there's any situations you guys ever want to talk about, we're happy to help. So we're right up at 1 o'clock, so I will let you guys go. But thank you guys again, and hope you guys all have a great rest of your Wednesday and great rest of the week.
Thanks, everyone. Have a good day.